phone is on vibrate mode.
Yeah.
Please put it on silent mode.
बहुत सारे लोगों ने खाली आपने मशीन से लॉगिन किया है ना, फॉर एग्जांपल लोन 1915 और फिर दूसरा है कुछ तो भी EPF3।
I think some
उनको क्या नेम चेंज कर दो।
Yeah.
उनको कहो क्या नेम चेंज कर दो, पार्टिसिपेंट्स में जाओ और राइट क्लिक करके वहाँ पे चेंज द नेम आता है, वहाँ पे खाली चेंज कर दो। मशीन से लॉगिन किया है ना, फाइल चेक के 1915 और फिर दूसरा है कुछ तो भी EPF3।
I think some
क्या नेम चेंज कर दो।
Yeah.
उनको कहो क्या नेम चेंज कर दो, पार्टिसिपेंट्स में जाओ और राइट करके वहाँ पे चेंज द नेम आता है, वहाँ पे खाली चेंज कर दो। मशीन से लॉगिन किया है ना, फाइल चेक के 1915 और फिर दूसरा है कुछ तो भी EPF3।
I think some
क्या नेम चेंज कर दो।
Yeah.
उनको कहो क्या नेम चेंज कर दो, पार्टिसिपेंट्स में जाओ और राइट करके वहाँ पे चेंज द नेम आता है, वहाँ पे खाली मशीन से लॉगिन किया है ना, फाइल चेक के 1915 और फिर दूसरा है कुछ तो भी EPF3।
I think some
क्या नेम चेंज कर दो।
Yeah.
उनको कहो क्या नेम चेंज कर दो, पार्टिसिपेंट्स में जाओ और राइट
Am I audible to you all?
Yes.
मशीन से लॉगिन
Okay.
किया है ना, फाइल चेक के 1915
The 50 messages are there.
I think some
क्या नेम चेंज कर दो।
Yeah.
नेम चेंज कर दो, पार्टिसिपेंट्स में जाओ और
Am I audible to you all?
मशीन से लॉगिन
Okay.
किया है ना, फाइल चेक के
yes.
1915
The 50 messages are there.
I think some
क्या नेम चेंज कर दो।
Yeah. Am I audible to you all?
Yes, ma'am.
Yes, you are audible.
Yes, ma'am.
yes. It is coming in loop. The voice is coming in loop. I think some it's getting repeated.
Am I audible to you all?
Yes, madam.
Yes, ma'am. Yes, ma'am.
Yes, you are audible.
Yes, ma'am.
It is coming in loop. The voice is
Yes, madam.
getting repeated.
Am I audible to you all?
Yes, madam.
Yes, ma'am. Yes, ma'am.
Yes, you are audible.
Yes, ma'am.
It is coming in loop. The voice is
Yes, madam.
getting repeated.
How?
Am I audible to you all?
Yes, madam.
Yes, ma'am. Yes, ma'am.
Yes, you are audible.
Yes, madam.
Yes, ma'am.
It is coming in loop. The voice is
Yes, madam.
getting repeated.
How?
Am I audible to you all?
Yes, madam.
Yes, ma'am. Yes, ma'am.
Yes, you are audible.
Yes, madam.
Yes, ma'am.
ये लोग को म्यूट कर से।
हेलो हेलो
Yes, you are audible, madam.
Good morning, ma'am. Good morning.
Hello. Hello. Said hello. No response.
Yes, sir. Good morning. You are audible, sir.
Good morning to you. How are you?
Oh, fine, sir. Thank you.
Okay.
How are you, sir?
And yes, I'm fine. And where is my friend Sofik Torani, professor?
He'll be joining shortly,
Okay, okay,
I hope.
okay. Nisha looks very excited, huh? Okay,
Sir, everybody is excited to see you and listen to you, sir.
okay. So you want firing from me? You want bullets or you want bouquet?
Bouquet.
You want bouquet? Okay, okay. No brickbats.
If you are firing bullets, then you should first give us bulletproof jacket.
Well, let me just think over it. And you may get some hard dose of medicine also in between. And sometimes I will give you mild medicine also. Don't worry.
Thank you, sir. Thank you.
In any case, both the medicines will work. Hello, you didn't say hello. Sumi, am I audible?
Yes,
Yes, sir. You're audible. Very loud and clear.
I tell all the participants to mute their audio video when we start.
Yes. Yes.
yes.
Do we have some time, Sumi?
3 minutes to go. 3 minutes to go, sir.
Yes. 1 or 2 minutes.
Introduce me, no? Who are the teachers? Who is teaching what?
Sir, I am teaching Constitution. I was teaching Constitution last semester, sir.
Oh, that is my subject, Constitution of India. Okay.
Yes, sir. Yes,
And
sir.
what do you teach now?
Right now, I will be taking sir CPC, Civil Procedural Code, along with that labor law.
Mhm.
Yes, and family law too. Yes.
And who is the other? Sumi is teaching Constitution, right?
I was teaching,
He
sir.
was, sir.
I was teaching Constitution. Then right now in the coming session, I'll be teaching Contract 2, I'll be teaching Administrative Law, plus Human Rights, Public International Law and Human Rights. Possibly, let's see.
I think we should start now.
2 minutes are left.
Another 15 minutes at least because participants are only 20.
Okay.
Your Silvassa is beautiful.
Indeed, sir.
We really
It's very
enjoy.
peaceful.
Very nice people.
Thank you.
Always smiling. Tafik has joined. Tafik Nurani.
No, sir. Not yet. I think we can begin now, and I request everyone to mute themselves. Only Shilpa ma'am can start. Shilpa ma'am. Shilpa ma'am.
Shilpa ma'am. Hello.
Madam, I believe
Shilpa ma'am.
we should meet for 15 minutes at least. Because most of the webinars start late. The participants in this, no? We need to go.
Nisha, I will speak for about 40-45 minutes only. Okay.
Okay, sir.
Okay. Because I'm very particular about timings.
Okay, sir.
મારો ફોન ક્યાં છે રશ્મિ પાસ મારો ફોન We are waiting for somebody, Nisha.
No, sir.
Okay, okay.
I think now we can start now. It's 10:33. Hello. Hello.
Hello. Ready, Sume? ફોન કર્યો છે ફોન નહીં તો કોઈનો આવશે અહીંયા જો મને ડિસ્ટર્બ થશે કોઈનો આવશે પાછો ફોન તો ડિસ્ટર્બ થશે We are waiting for somebody, Nisha. Hello.
No,
Are we-
sir.
Okay.
Hello.
Okay. Ah. We are not waiting for somebody, right?
Yes, sir.
No, sir. No, sir. No, sir. Yes, sir.
I'm really sorry, everyone. I guess there are some technical issues.
Yes, ma'am.
Should we start?
Yes, ma'am. Please.
Okay.
Yes,
A
ma'am.
very good morning and a warm welcome to everyone. Myself, Professor Shilpa Tiwari, and on behalf of Srimati Devkiba Mohansinhji Chauhan College of Law, I present myself as the host of today's webinar on the topic of the Constitution of India and fundamental rights in the present testing times of COVID-19 pandemic. Friends, as we all already know that education is the key to create a society which is dynamic and productive, offering opportunity and fairness to all. It's one of the most essential indications of human development, the importance of which cannot be undermined. It unlocks the treasure that lies within all of us. And to ensure our motto, education in the service of society, we have come on this platform today to gain knowledge from Dr. Kaushik Oza sir, who is our resource person and will address us on today's topic. Um, Dear participants, before we begin, I request everyone to drop your questions or queries in the comment or box or a question box. In the chat box, we shall put them across to our resource person during the question and answer session, which is scheduled after his lecture. So now, without a further ado, I will turn the time over to Ms. Suman Sharma ma'am and to welcome our resource person, Dr. Kaushik Oja sir. Over to you, ma'am.
Hello. Good morning and a very warm welcome to everyone. My name is Professor Ms. Suman Sharma and I'm from Srimati Devkiba Mohansinhji Chauhan College of Law. And we have all come together today on this platform by means of this technology. And we are here to have a brief insight and knowledge on the today's topic, which is the Constitution of India and the fundamental rights in the present testing times of COVID-19 pandemic. At the outset, as I welcome you all, I would like to express my heartfelt gratitude to the Honorable Chairman, Shri Chauhan sir, and the Management Committee, who has always been instrumental in giving us support and encouraging us to do the best we can, even during these times when we are facing the crisis. I wish to thank all of them on behalf of the entire Law College staff. Also, we as human beings have always considered ourselves to be the superior species. And today the scenario is that a very tiny virus has shaken our egos and we have realized the importance of survival. And this pandemic, it has taught us a lot. And most importantly, it has taught us two very important virtues. The first is that of resilience, and the second is adaptability. And so is the reason that we have chosen this platform to educate our children and to also educate the people around us from the legal and the non-legal fraternity so that we can get ourselves acquainted with the topic that we have chosen today, which will be mainly highlighting on the Constitution of and the fundamental rights during the testing of the pandemic and the COVID-19. So today I'm given this privilege to be addressing and to be able to introduce our resource person, our very own Dr. Kaushik M. Oza sir. Dr. Kaushik has studied MA in American political system and PhD on the topic, the judicial philosophy of late Chief Justice Earl Warren of USA. Sir took 7.5 years to complete his PhD in the year 1991 after interviewing more than 600 legal luminaries in India as well as in USA. He was associated with Georgetown University, Washington, D.C., and has also been associated with US Supreme Court. He has represented India twice at Salzburg Seminar, Austria in 1989 and 1997, respectively. Sir was the former vice president of David Sasson Library, which is a 154 years old UNESCO World Heritage Site. He is candid yet cautious, firm yet decisive. Sir is a member of an NGO which is based in Mumbai, that is Human Rights Action Group. He is a corporate trainer and has been giving in-house training program for last 30 years. He has a deep interest in psychology. He is a close observer of Supreme Court and was very close with late Justice William J. Bennett. Sir, at his age of 64, is still a student and is still learning. He firmly believes in saying that what we know is handful and what we do not know is as large as the world is. So without much ado, I would request our in-charge principal, Ms. Nisha Pareekh ma'am, to address the participants and also to declare the webinar as open. Over to you, Nisha ma'am. Ms. Nisha?
Hello. Hello.
निशा बोलती નથી.
Hello.
Hello.
I think due to some technical issues, the network connection of Nisha ma'am got disconnected.
I have joined from Rajveersinh.
Suman, am I audible?
Yes, yes, Rashmi ma'am, you're audible.
Ma'am, I am audible?
Yes, yes, Nisha ma'am, please take
Okay.
over.
Okay. Honorable Chairman Shri Fatehsinhji Chauhan sir, resource person of today's webinar, Dr. Kaushik Oza sir, management committee members, principal of Srimati Devkiba Mohansinhji Chauhan College of Commerce and Science, Professor Dr. Ambadas Jadhav sir, professors, teachers, my dearest students, and all the participants of this webinar, a very warm good morning to you all. As we all know, in the month of December 2019, World Health Organization was first informed of cluster of cases of pneumonia caused by coronavirus in Wuhan city, China, which has now caused an outbreak of respiratory illness across 213 countries. The first case of pandemic in India was reported on 30th January 2020. The COVID-19 pandemic was the COVID-19 pandemic, which has resulted in global lockdown, is a crisis as never before. In India, a 3-week lockdown in the nature of curfew was announced with 4 hours notice by Prime Minister Shri Narendra Modi on 24th March 2020. On Ambedkar Jayanti, 14th April 2020, the lockdown was extended for a further 3 weeks, this time with no advance notice. In intervening period, India witnessed the largest departure of workers and migrants on highways, reminiscent of partition. A pandemic is serious, and in public health emergency, drastic containment measures are unavoidable. Even by this token, however, a total lockdown has been widely seen as the harshest coronavirus containment measure in the world. The pandemic crisis introduced state to an unusual notion of fundamental rights competition. The obligation of states to protect the rights to life has to be balanced against other fundamental rights such as right to freedom of movement, right to privacy, and right to freedom of speech. The question of whether states have established the right balance between these rights must be continuously evaluated. We should also think about right to health of non-COVID patients as many private clinics and hospitals are closed during this lockdown. Citizens have been forced by the state to stop their work, which is directly connected to their livelihood. The people belongs to middle class are under tremendous pressure to borrow money to feed their families and pay rent for their accommodations. The government should have made arrangement for shelter, food and other items for people who were affected by the order of lockdown. The right to livelihood is comprehended in the right guaranteed by Article 21 of the Constitution that no person shall be deprived of his life and personal liberty except according to procedure established by law. The word life as employed by Article 21 takes in its sweeps not only the concept of mere physical existence, but also all finer value of life, including the right to work and right to livelihood. The guarantee of personal liberty is contained in Article 21, likewise, the right to reside and settle in any part of territory of India is guaranteed by Article 19(1)(e), and the right to carry on occupation, trade, or business, which is guaranteed by Article 19(1)g. The only provisions which lead to suspension of fundamental right has been incorporated under the Constitution of India during emergency caused by war, external aggression, or internal disturbance. Article 19 of the Constitution of India, which used to get suspended by the proclamation of emergency, will not get suspended if the ground of emergency is only armed rebellion and not war or external aggression. Right to life and personal liberty under Article 20 and 21 of the Constitution of India cannot be suspended during emergency. Now, imagine a situation where person aggrieved with the acts and omission of the executive is denied access to justice because he will not be allowed to travel to the state capital to approach the High Court of State for redressal of his grievance. Even courts are not working or courts are not functioning at their full strength, and lawyers can only have access to justice via video conferencing, that too in in urgent cases to be decided by the court. By this webinar, we attempt to foreground dimension of justice, fundamental rights, and constitutionalism in the testing time of COVID-19 pandemic. Students, today we are grateful that we have Dr. Kaushik Oza sir with honor with us and on this with his sound knowledge. Once again, I welcome you, sir, and I wish you all a fruitful discussion ahead. Now, I am requesting Dr. Kaushik Oza, sir, to start his session and to share his knowledge with us. Thank you.
Okay. गीता दत्त सम्राट
ये मत कहो खुदा से मेरी मुश्किलें बड़ी है, ये मत कहो खुदा से मेरी मुश्किलें बड़ी है, ये मुश्किलों से कह दो मेरा खुदा बड़ा है। आती है आंधियाँ तो कर उनका खैर मकदम, आती है आंधियाँ तो कर उनका खैर मकदम, तूफान से ही तो लड़ने खुदा ने तुझे गढ़ा है। ये मत कहो खुदा से मेरी मुश्किलें बड़ी है, ये मुश्किलों से कह दो मेरा खुदा बड़ा है, मेरा खुदा बड़ा है, मेरा खुदा बड़ा है। अग्नि में तप के सोना है और भी निखरता, अग्नि में तप के सोना है और भी निखरता, दुर्गम को पार करके हिमालय कोई चढ़ा है। लाएगी रंग मेहनत आखिर तुम्हारी एक दिन, लाएगी रंग मेहनत आखिर तुम्हारी एक दिन, होगा विशाल तरवर ये बीज जो पड़ा है। ये मत कहो खुदा से मेरी मुश्किलें बड़ी है, ये मुश्किलों से कह दो मेरा खुदा बड़ा है, मेरा खुदा बड़ा है, मेरा खुदा बड़ा है। जब साथ है हमारे ओ सर्वशक्तियों से, जब साथ है हमारे हर काम उसके रहते आसानियों से हुआ है। कभी हार ना, हिम्मत का कदम बढ़ाओ, कभी हार ना, हिम्मत का कदम बढ़ाओ। हजारों कदम बढ़ाने वो सामने खड़ा है। ये मत कहो खुदा से मेरी मुश्किलें बड़ी है, ये मुश्किलों से कह दो मेरा खुदा बड़ा है। ये मुश्किलों से कह दो मेरा खुदा बड़ा है, मेरा खुदा बड़ा है, खुदा बड़ा है, मेरा खुदा बड़ा है।
Okay, ready? Hello, am I
Yes.
audible?
Yes, sir.
Okay, do I start?
Yes, sir.
Okay, very good morning to one and all. Did you like the song?
Yes, sir.
Because this
Yes,
is,
sir.
I just thought that this is energy booster and it will rejuvenate and recharge our batteries. So very good morning to one and all. At the outset, I would like to thank Fatehji Chauhan, sir, and Devkiba Mohansinhji Chauhan Law College, principal, vice principal, members of the staff, in particular Suman Sharma, Nisha Pareekh, and all other members for giving me this opportunity. I would also like to thank my sister, Dr. Rashmi Oza, because of whom I got this opportunity to express my views in front of you. Now, my friends, before I start, I would like to make a confession that I will try to be impartial and honest, because for me, impartiality is a dream and honesty a duty. Am I audible? Hello, am I audible?
Yes, sir.
Yes, sir.
Yes, sir.
Okay. Now, since we are going to talk about the Constitution, the most important thing about the Constitution, which I would like to put in front of you, this was the interview conducted by me with Justice William Joseph Brennan of US Supreme Court way back in 1987. It is very rightly said that the genius of the constitutions rests not in any static meaning it might have had in a world that is dead and gone, but in the adaptability of its great principles to cope with the current problems and needs. My friends, today, the world has become victim of well-planned strategy and conspiracy hatched and implemented by China to disturb the world order and peace, to destabilize the countries that were potential threats to China. It is a crime against humanity with mass destruction, death of human population throughout the world. China must be punished and isolated by the different countries. It should be disqualified from UNO. It is undeclared war, World War III, with actual malice to malign the countries which are not in its good book. It wants to become the superpower, dream cherished by it for a long time. The world order has been disrupted, disturbed, and shattered by devil China. Immediately after the First World War, that is in 1914 to 1918, what happened in 1919 and 1920 has been repeated in 2020. History tells us, but history never teaches us. The Malthusian theory of positive and preventive checks of 1798, along with Darwin's theory of survival of the fittest, have found valid with strong backing of logic and reason. China has been the biggest enemy of human rights. As we all know, 60% of the property is occupied by the China, 60% of the property. If you hear the speech of Sonam Wangchung, the tribal leader of Ladakh, you will come to know he has specifically argued and favored that we should use wallet rather than bullets to check China's ambition. It is high time that we totally boycott all the goods of China, and it should be taught a lesson, right? I would see China is the biggest violator of human rights and fundamental rights. I would like to give you one example. My sister was invited some years back to Beijing to address human rights conference, but she was detained at Beijing airport by the immigration officer for the simple reason they were very suspicious of human rights conference. Then she tried her best to persuade them, but then she was told that she should give a call to our host and call her to the airport. Then somehow with great persuasion and arguments, she was given permission to enter China to Beijing, despite official invitation on, that was a conference on human rights, okay? Now, as you all know, China is the biggest enemy of human rights, okay? Now this COVID-19, the epicenter was Wuhan. Deliberately and purposely, the virus was leaked from the lab to spread the reign of terror. No effect. We all are really surprised, despite this virus of COVID, corona, there was no effect in Beijing and Shanghai. Wuhan is today totally corona-free. International Court of Justice and World Health Organization must uphold the conviction of China, the dangerous monster, the dragon, the guilty of killing billions of human beings. Out of 156 countries today where happiness survey was done, our country is at 140. There are only 2 countries in the world where they have the Ministry of Happiness. This is very, very important in these trying times. You know, there are only 2 countries in the world where they have this Ministry of Happiness, that is United Arab Emirates and Bhutan. Talking of our country, most of the time, violation and abridgment of fundamental rights is at the hand of law enforcement agencies. In the present gross violation of human rights, right of freedom of speech and press, the fourth estate is example of Arnab Goswami, which you must have heard. State government of Maharashtra in general, and in particular the state home ministry, tried to tamper with the rights of free speech and press. Our Mumbai, being the financial capital of the country and the epicenter of our economy, apart from being the largest contributor of income tax to the national exchequer, what specific privileges and rights do we enjoy in the present turbulent time where our patience is tested? We are really very, very lucky to have strong leadership at the central level. Our country is in the safe hands. When you will think of other way, you will get jitters. Our expectation from the government is too much. In the present testing times, nation comes first. We must take into consideration ground realities and facts. Germany, who spends 60% of its GDP on its people, though the gap between the have and have-nots has widened, as we need to come out from this economy slowdown. I also fear worldwide depression of 1929 after we come out from the clutches of COVID-19. I expect some hard steps and drastic revolution under the given circumstances. I don't think Modi government has violated any of the fundamental rights of any people setting aside well-set norms and democratic principles. It has not altered the basic structure of the Constitution or tampered with the preamble. Fundamental rights of the migrant workers, when they were allowed to go to their respective states, the central government met the expenses to the tune of 85%, and states were allowed to bear the balance 15% of the expenses. The challenges faced by the government and its ability and skills to tackle the problem should be hailed. We all are victims of time and circumstances, taking into consideration the felt necessities of time. I don't think any fundamental rights are violated or abridged. In the time of crisis, now my friend, this is very important. In the time of crisis, nation comes first, and not the party politics, clash of ideologies, groupism, communal hatred, etc. If you are not loyal to your nation, then you are undoubtedly traitor. The best part of our constitution, we have borrowed heavily from Universal Declaration of Human Rights. Our Constitution Assembly member, Mr. B.N. Rao, was specifically advised by Frankfurter, the then judge of US Supreme Court, to insert the clause procedure established by law. I would like to avoid any controversies, but the recent unhealthy trend really disturbs me. That is, the parliamentary supremacy has been time and again forced to surrender to judicial supremacy. I'm talking about the present trend. Why every act of government passed in the parliament by two-thirds majority needs the approval and clean sheet from judiciary, from the apex court? High time to define and specify what is the basic structure by the full bench of our constitution, by the full bench of the Supreme Court. The best part we can learn from the American Constitution, we should have something like 22nd Amendment in our Constitution, where it specifically mentions that no person can serve the country for more than 2 terms. This is the best thing we can learn from the American Constitution. Our Constitution is silent on many issues. For example, 22nd Amendment and the then Law Minister H.R. Gokhale are blocked to our democracy when we talk about the violation of human rights. I'm also critical of the role of the governors of different states. They have been made glorified servants of the center. We all know who is responsible for that. Any problem? Hello, am I audible?
Yes, sir.
Yes, sir.
Okay. Few days back,
Yes, sir.
You all remember we celebrated 44th anniversary of ADM Jabalpur versus Shiv Shankar Shukla, the famous habeas corpus case of human rights. Majority of the judges surrendered. I use the word surrendered. Majority of the judges surrendered and sold their conscience to the government. I would repeat again, there was few days back when we celebrated 44th anniversary of ADM Jabalpur versus Shiv Shankar Shukla. Now, this is the most famous case violation of fundamental rights, human rights, famous habeas corpus case of majority of the judges surrendered and sold their conscience to the then government under duress. They agreed and approved the wish of the government to abridge the basic fundamental rights. It was a cold-blooded murder of democracy. The democracy was put into ventilator. The one and only judge who dissented was Justice H.R. Khanna. who made the history and kept the democracy alive. Our constitution was, in the words of Palkiwala, defaced and defiled. 37 years after Mr. Justice P.N. Bhagwati thinks proper to give public apology, that is a good part on his part, that I really made a blunder by going with the majority. But what I mean to say is harm is already done. What is the use of now asking for public apology? But anyway, he cleared his conscience. So that is a good thing about Justice P.N. Bhagwati. It is, and he was also he said that my ambition at that point of time when I joined the majority was I wanted to become the Chief Justice of India. He succeeded Y.V. Chandrachud. It is high time that we make certain constitutional amendments, the vexing problems and the issues which we are facing in the present times. Constitution is in the end a fragile, cohesive document. Anything done in the name of expediency may prove fatal and may lead to crisis. Our constitution has to be very specific about electoral reforms, religious freedom, the working of the parliamentary system of government, code of conduct for the elected representatives, etc. It should be indestructible union of indestructible states. Now, the present trend, which very often I have noticed, is really very disturbing and something which is we need to do something. The present trend of some of the states of India is very disturbing. I see the secessionist activities, attitude on their part. Very often I fear, God forbid, we may meet the fate of USSR, which became Russia. The Constitution of India does not permit any state to pass the resolution against the law passed by the parliament with 2/3 majority. It is a bad precedent as it may often raise the question of patriotism and loyalty to the country. Please try to understand me in the right perspective with the open mind. We should not force for any provisions of the Constitution to bring into fundamental rights which are not enforceable in any court of law. It is the duty of the judges of the higher courts, setting aside their ambition and lucrative future, to interpret the laws and not to read in between the lines. The present trend of legislating, now I'm talking about the present trend of legislating rather than interpreting the laws by the higher judiciary is a dangerous trend. Nobody has got any blanket rights to play havoc with the Constitution. Checks and balances are must along with separation of powers. On the issue of national importance, nation comes first. Let us not give the wrong signal to the world. Ours is one of the best constitutions with parliamentary system of government. I would also like to bring it to your notice that in the final draft of the Constitution, many changes were made abruptly. This irritated the chief architect of the Constitution, Dr. B.R. Ambedkar, who had to say, "This is not my Constitution. This may be subject to debate and controversy, which I would like to keep away." But one thing more I would like to tell, that nowhere in the Constitution of India the word minority is defined. Nowhere in the Constitution of India the word minority is defined or explained. Take it from Article 25 to 30. Article 29 and 30 just mentions about linguistic and religious minorities, but it does not give any clarification that how do we identify religious and linguistic minorities. This is something which we need to do introspection. Many inevitable changes are required in our Constitution if we have to stand the test of time. One nation, one Constitution, one flag, one law. I'm not talking about personal laws. Strict law against people spreading communal hatred, violence. No religious conversion, reservation on the basis of economic status, no mob lynching, no recital of preamble or any other means to prove your patriotism. Let us learn from United States of America. Indians are Indians. Everyone needs to merge their identity. Let us become melting pot. No special status to why special packages are given to northeastern states? Are they not part of India? And funny thing, in northeastern states, I would like to talk about Lakshadweep, Mizoram, and Nagaland, where Hindus are 3%, Christians and other communities, Muslims, they are majority. But Hindus are classified as majority in these three particular regions, Lakshadweep, Mizoram, and Nagaland. This is something which we need to do, have a look at it. I would also like to bring to your notice that in the final draft of the Constitution, many changes were made. Okay. Now, people who say that they are not, now this is something very sensitive issue. People who say that they are not feeling safe in this country. People, inverted commas into quotation. People who say, I know I'm, you must be knowing I'm referring to whom. People who say that they are not feeling safe in this country should be given choice to leave the country because they made the name, fame, and money in India, and now they want to spread communal hatred. Capital punishment for rape convicts should be there. No appeal. To implement National Judicial Appointment Commission. Collegium system has not worked properly in our country. There are many lapses on all the issues of national importance, hearing by the full bench of more than 15 judges. I see only few selected judges of the bench for hearing. Others are bypassed or overlooked for the reasons best known to you and me. No appointment of any retired Chief Justice or any judges to any house or gubernatorial post. Many of the clauses, articles, provisions needs to be redefined, like the basic structure, and the most important, the question which I would like to pose to all of you: what serves liberty best? What serves liberty best by way of restriction of authority? Now, it is very important. I would like to do a critical evaluation of our constitution and violation of fundamental rights. Attempts were made to destroy the very basic structure of our constitution, setting aside all the democratic norms. I have chosen the following landmark judgments of the apex court. You must go through Minerva Mills versus Union of India 1980 case. The judgment was 4-1, but I would recommend that you don't read the majority judgment, but you must read the dissenting judgment of Justice P.N. Bhagwati. The notorious parliament, I use the word the notorious parliament that time, under the leadership of the then Prime Minister, with actual malice, made an attempt to take away the power of judicial review. Through the decision of Minerva Mills, an attempt was made to take away the power of judicial review from the apex court through the monstrous 39 Constitutional Amendment Act of 1975. The Parliament inserted Nationalization Act of 1974 into the 9th schedule. The villain, now I'm little blunt and little outspoken, the villain and the murderer of democracy was the then Law Minister, Mr. H.R. Gokhale, the chief architect of 42nd Amendment. The dissent of Justice P.N. Bhagwati kept the democracy alive by not going with the majority. The litmus test of the court was of basic structure. Okay. The court took the liberty to redefine Golaknath case Parliament failed in its attempt to force judiciary to surrender its supremacy. The rest is history. Now, I would like to come to Golaknath versus State of Punjab, 1965 case. The judgment was 6-5, 6 majority and 5 were dissenting opinions. At that time, Chief Justice was Subba Rao. It dealt with Article 368, provisions related to the amendment of the Constitution. It redefined Article 368. The court referred to Article 245, 246, 248. The court held that the amending power and legislative powers of the parliament were essentially the same. I repeat, this is very, very important what happened in Golaknath case. The court held that the amending power and the legislative powers of the parliament were essentially the same. Therefore, any amendment of the Constitution must be deemed law as understood in Article 13, subclause 2. The court warned the parliament that it cannot enter the prohibited area and undo or destroy the basic structure. Golaknath case was the tight blow to the Congress party. People of India were not ready to accept the forced parliamentary supremacy. Democracy at last survived because of Golaknath case. Now, another important case when we are talking about the Constitution and fundamental rights is Keshavananda Bharti case versus State of Kerala and others, 1973 case. Judgment can be found in 11 separate judgments. 11 judges wrote separate judgment. The seminal concept of the basic structure of the Constitution gained recognition. The seminal concept of the basic structure of the Constitution gained recognition in the majority verdict. But what is the basic structure? There was no consensus. As some of the judges were in a mood to please the government, and some wanted to remain in the good books, some were more sensitive and did not allow the lamp of justice to go out in darkness. They secured their place in history. Few of them remained neutral as they were not ready to take the risk. Anticipating future should be bright. One more attempt to kill the democracy and to set aside democratic norms proved futile. One very, very sensitive case, which I must bring it to your notice, is Mrs. Paramjit Kaur versus State of Punjab and others. It was delivered on November 15, 1995. Jaswant Khalra case, as it is known. The case will give you jitters. It was a tight blow to the law enforcement agencies. High time court felt it was high time policing the police by handcuffing them. It was shame on the police department of the state of Punjab after blinding of the Bhagalpur under trial prisoners. The cold-blooded murder of Jaswant Singh Khalra, the human rights activist, by the police through third and fourth degree torture can never ever be forgotten. Punjab State Police played the role of General Dyer in post-independent India. Unfortunately, till to date, we have signed the International Torture Convention, but we have not ratified it. I repeat, unfortunately, we have signed the Torture Convention, but unfortunately, we have not ratified the Torture Convention till to date. Is it not the right time to do some introspection when we are making big claims of democracy and human rights? We must do something. We all should initiate the action. All the police officials responsible for the murder of Khalra should be hanged in public. My friend, in today's time and circumstances, the logic and rationale of John Marshall Harlan, he was a vigorous dissenter in the Warren Court, is very appropriate, What he said, now this is very, very important. The Constitution, now this should be taken note of. I'm reading it very slowly. The Constitution is not a panacea for every blot upon the public welfare, nor should this court ordained as a judicial body be thought of as a general heaven for reform movements, is more valid and appropriate in today's time. My friends, we are now at the point where we must decide whether to honor the concepts of plural society, which gains strength through diversity, or whether we are to have bitter fragmentation that will result in perpetual tension and strife. This is one of the most important challenges before our judiciary. Rightness of the cause and reasonableness of the cause is one more important challenge before our court. I would like to say something which perhaps may not be accepted in totality. There may be a sharp reaction or criticism also, but anyway, nobody can stop me from expressing my opinion. Anyway, these are my ideas and convictions, you like it or not. The recent trend of our apex court has been the recent trend of our apex court has been to prove its supremacy has time and often returned beyond the established and accepted boundaries. I repeatedly appeal to our court to follow a number of practices designed to avoid unnecessary or premature judicial intervention, such as allowing administrative process to run their course, not passing on the validity of the state statutes that have neither been enforced or nor interpreted by the state courts, avoiding issues and refusing your appeals of non-final orders. The court must show deference to other decision-making authorities, which unfortunately they are not showing. Let us remain committed to the stable and predictable development of law. My protest may be noted down when the court resolved important issues by way of summary disposition. Yet Justice Arthur J. Goldberg, member of the Warren Court for the short period and liberal, told me in an interview with me that trend of growing manifestation against the dry and sterile dogmas with virtually unfounded assumption is growing and have become inevitable. Now, my friends, when I criticize judiciary, I also must mention that the judicial duty is heightened when other checks prove to be ineffective. Why judiciary has to intervene, when other two branches of the government are blind to the fundamental injustice or problems. The judicial duty is heightened when other checks prove to be ineffective. Courts cannot be blind to the fundamental injustice in its. The court cannot be blind to the fundamental injustice. It is left with no alternative but to act. There is overall wide acceptability, I would say consensus, and firmly support a simple doctrine of judicial finality. A notion that the court is the last word in the constitutional government, that it is constitutional activities is not to be checked or externally restricted. Supreme Court's activity of constitutional construction is properly sheltered from the reciprocal oversight of the other branches. Now, I quote, "We are not final because we are infallible," goes Justice Robert Jackson's oft-quoted aphorism. We are infallible because we are final. The decisions of the court has to take into consideration the felt necessities of time. Now, I would like to give you an example. You know why the American Constitution has survived for more than 250 years? When the Constitution of America was drafted, of USA, America drafted, and when the founding fathers were coming out from the Liberty Hall of Philadelphia, a passerby just asked Benjamin Franklin, "Sir, what did we get?" And the answer came, "A republic if you can keep it." So it is high time, we need to have a second look at our constitution, because there are many provisions, there are many articles which needs to be revised and rechecked, because our constitution is silent on many issues and many other things which are faced by the nation. My friends, J.S. Mill wrote in his book on liberty, "No slumber is deeper than that of a deep-seated desire man can gain only by disturbing it." And one thing more which you should always remember is, when you read about the Constitution, fundamental rights, abridgment of fundamental rights, that is, there is a mighty big difference. There is a mighty big difference between good reasons, sound reasons, and reasons that sound good. There is a mighty big difference between good reasons, sound reasons, and reasons that sound good. And last but not the least, if we are to be guided by the light of reason, if we are to be guided by the light of reason, we must let our mind be bold. That is what Justice Louis Pranay said of US Supreme Court. And my friends, no man can be grateful at the cost of his honor. No woman can be grateful at the cost of her chastity, and no nation can be grateful at the cost of its liberty. Thank you very much. God bless you. Hello.
राही तू मत रुक जाना, तूफान से मत घबराना, कभी तू मिलेगी तेरी मंजिल कहीं दूर गगन की छाँव में। राही तू मत रुक जाना, तूफान से मत घबराना, कभी तू मिलेगी तेरी मंजिल कहीं दूर गगन की छाँव में। माना कि गहरी है धरा, पर है कहीं तो किनारा, तू भी मिला आशा की सुर में मन का ये एक तारा, तू भी मिला आशा की सुर में मन का ये एक तारा, कभी तू मिलेगी तेरी मंजिल कहीं दूर गगन की छाँव में। राही तू मत रुक जाना। सबका वो ऊपर वाला, सबको उसी ने संभाला, जब भी घिरा गम का अंधेरा उसने किया उजियाला, जब भी घिरा गम का अंधेरा उसने किया उजियाला, कभी तो मिलेगी तेरी मंजिल कहीं दूर गगन की छाँव में। राही तू मत रुक जाना। तू फंसे मत घबराना, कभी तो मिलेगी तेरी मंजिल कहीं दूर गगन की छाँव में, दूर कहीं दूर कहीं दूर कहीं दूर।
If you write anything on your computer, you need
Thank you so much, sir.
Pretty much all day, every day, and Grammarly makes my writing better.
As a student,
Am I audible to you all?
is correcting everything as I'm writing.
Thank you so much, sir, for for guiding us with the pearls of your wisdom. Now we will go ahead and take some time for question and answer sessions. Just a reminder before that, that please be sure to type your questions into the question box only. It looks like we have few questions here. Sir, Aarti Bajpai from SYBLS LLB asks that what are your views on the DPSP, Directive Principles of State Policy of Constitution, in this pandemic situation?
You meant to say directive principles?
Yes, sir. That's what she's asking.
See, in this pandemic situation, directive principles of the state policies, uh, first thing first, Aarti must be knowing that it is not enforceable in any court of law. So that are just recommendatory by nature and very little thing we can do about it. But then you never know that in future what happens, like Article 370, Article 35A. But at right now, in this pandemic situation, they give good guidelines, directive principles to the states, to the national government. But unfortunately, like National Human Rights Commission, its recommendations are not binding. So that is very unfortunate.
Okay. So moving ahead, so we have next question from Tripti Chauhan from TYBLS LLB. Sir, how do we ensure checks and balance being under the umbrella of Constitution? In this, I guess she is asking it in the context of this pandemic situation, that how do we ensure checks and balance being under the umbrella of Constitution?
Let me be very candid and let me be very outspoken, in our country, sometimes it becomes very, very difficult to have these three different compartments, checks and balances, because most of the time we are more influenced by George Orwell's 1984 novel, that Big Brother is watching you. And in the recent times, we have grossly violated the provision of checks and balances, because time and again, parliamentary supremacy has been overlooked and judiciary has entered the area which is generally regarded as prohibited, right? It wants to, judicial supremacy is proved time and again. And I just fail to understand, when an act is passed by the parliament with 2/3 majority, why every time we need the clean sheet from the apex court? See, a law is passed by the parliament. Parliament is supreme. There is a clause in our constitution procedure established by law. Had it been due process of law, it would have given more power to the judiciary. But I very often think, I'm talking about the present court, present apex court, that it is not interpreting the laws, it is reading in between the lines, and it is legislating. That is my personal view. I may be wrong or I can be challenged also.
Okay, moving ahead. So we have one more question from Santhome Trichy. So would you please repeat your views about the minority rights and religion that you noted in your talk?
Very good question. See, in our constitution, we have not explained or defined minority. First thing first, there has been a PIL which is filed in the apex court. An RTI was done by one of the eminent lawyer of India, and the government it is on the record, and government gave the reply that we don't have clear-cut guidance on the rights of the minorities. Article 29 and Article 30 just speaks about linguistic and religious minorities. There is no clear, nowhere in the constitution the word minority is defined, what the minority is, what are its rights. And I just fail to understand how come we had this minority commission in 1993 when there are no clear-cut guidance, at all. These are again my views. I may be wrong, and I am subject to correction. That if at all reservations are to be there, it should be for the backward economic class. And I gave you example of Lakshadweep, Nagaland, and Mizoram, where Hindus are 3%, but still they are regarded as in majority, and other communities are regarded as minorities. So there is no clear-cut guidance, and I don't know what stand will the Supreme Court of India take. But this is something a cause of worry. Just Article 29 and 30 speaks about religious and linguistic minorities, and that too, it does not go into detail and tell us that what does it mean, whom you will regard as religious and linguistic minorities. They have to be a little more specific. They have to go into details, and some constitutional amendment is required in this matter.
Okay. So moving ahead, we have one more question from Shrikant Mishra of SYLLB. Sir, please guide us that how Constitution will safeguard Article 20 and what are some protective measures which should be taken. I guess again he is asking in terms of the pandemic situation, so that what protective measures should be taken.
Okay. See, when you, in the given circumstances, there has to be proper understanding, first thing first, between all the three branches of the government, right? Now, if some steps are taken by the government of the day, central government, immediately Supreme Court, the apex court wants the clarification from the government, right? If there is no proper coordination between the executive, legislature, and the judicial branch of government, there is, because what I see in the present circumstances scenario is there is a tug of war, right? And there is a tug of war, like who wants to play the role of Big Brother of George Orwell's 1984 novel. So some amendments are required, some clarifications are required, and I think we should bring some amendments in the constitution, some changes in the constitution, which will give clarification, which will give specification, and which will give explanation and justification as to why friction will not take place in future. So there is a lack of coordination undoubtedly between all the three branches of government. That is what I personally feel. Don't consider me as a pro-government or anti-government. Please take me in a right sense, because in the beginning only of my lecture, I told you that I will try to be impartial and honest. Okay?
Sure, sir. Due to shortage of time, now we are taking our last question. Sir, in your opinion, whether Constitution be rewritten or amended? That is what asked by Professor Dr. Ambadas Jadhav, sir, who is also our principal of Commerce and Science. And along with that, he is also our student in TYLLB. So he is asking the question, sir, that in your opinion, whether the Constitution be rewritten or amended?
Okay, to this question, I would not like to answer, but I would like to put counter question. Am I at the part of the problem or part of the solution? If you are the part of the problem, then you need to redefine the constitution. If you are the part of the solution, then blah, blah, blah.
I think we all got our answers, sir. Thank you so much. Thank you, sir. And thank you, everyone. We appreciate you being here. Along with that, I would like to make a small announcement that students and past participants who need to fill the feedback form, the link of which is available in the description and in the chat box as well. This is mandatory to fill in order to get your e-certificates. And for the final segment of this webinar, I would like to invite Mr. Rajveersinh Parmar for the vote of thanks. Over to you, sir. Thank you. Thank you once again.
Hello. Am I audible?
Yes, sir. Yes, sir.
Hello. Good morning, one and all. Myself, Rajvi Parmar, Assistant Professor of Srimati Devkiba, Mohansinhji Chauhan College of Law. As the saying goes, the essence of all beautiful art is gratitude. I deem it a great honor to have been asked to propose a vote of thanks on this memorial occasion. I, on behalf of our in charge principal, professors, staff, technical team, and the entire college, extend a very hearty vote of thanks for our successful completion on today's webinar on the Constitution of India and the fundamental rights in the present testing times of COVID-19 pandemic. First of all, I would like to express a very special and heartfelt thanks to our distinguished speaker, Dr. Kaushik Oza sir, who blessed us with his virtual presence and took out valuable time from his busy schedule for us. The way he explained the topic and shared his knowledge and answered all the questions was exemplary. Thank you, sir, for your interesting and thought-provoking session. I would also like to express my gratitude to our honorable chairman, Shri Fatehsinhji M. Chauhan sir, for always inspiring and supporting us to conduct such virtual sessions. I would also like to thank our secretary, Shri Devdas Shah sir, treasurer, Shri Vishwesh Dave sir, and all management committee members for guiding us and always encouraging us. I would also like to express my gratitude to the in-charge principal of Srimati Devkiba, Mohansinhji Chauhan College of Law, Mrs. Nisha Pareekh ma'am. The amount of energy you possess is immeasurable. Your lively personality keeps everyone on their toe. Thank you, ma'am. I cannot thank everyone enough for their willingness and involvement to take on the completion of the work beyond their comfort zone. So I specifically thank the people who have been the backbone of the event, our professors, staff, and the technical team for their cooperations in the institution of this function. We are fortunate enough to be backed by a very dedicated and motivated team who knows their task and are very much result oriented. And finally, I would like to thank all our dear participants for joining with us today. It has been a great pleasure and hope the session was very informative. Thank you all once again. And kindly take a note that e-certificates will only be issued to the participants who have submitted the registration and the feedback form, which is provided in the description box below. So I kindly request all the participants to fill the feedback form. So here we come to an end in today's webinar. I hope all of you have enjoyed the session. Thank you all. Thank you so very much for being with us. Thank you.